Hey everyone, welcome to the BU-231 final review. So what we're going to do today is I'm going to briefly walk through what to expect for the exam, how to do well on the exam, and then I'm going to do another kind of speed run through the topics. I'll leave off the last two topics of that speed run since we just did them together. But I'll walk through kind of everything that we've done today, kind of focusing more on the important things from there. So again, the final exam is 2 hours, right? It's non-cumulative unless you didn't write the midterm for whatever reason, in which case you are writing a cumulative final. For those writing the cumulative final, you can take the midterm guide, including the video I prepared for the midterm, and the final guide and put those together, and that would be the same thing as if we had put together a final review guide for you. It's going to be cumulative. It's going to cover the same types of topics that the midterm and the final covered. That's only for a minority of people in the class. For everyone else, right, you're writing a non-cumulative final, so only things after the midterm. Pursuant to the syllabus, the final is worth 50% of the grade, and it's a very similar format to the midterm. Won't be any surprises, right? It is a fact pattern hypothetical exam, exactly like the midterm, different topic, different story, and there's going to be 7 short answers and 1 multiple choice, which was the same as the midterm as well. So final exam should be familiar. The way in which you answer questions is familiar. All the instructions are familiar, but I'll review those a little bit. And so just follow the same process that we talked about for the midterm for reviewing for the final. In terms of office hours, I'm happy to meet. I'm happy to answer emails. I might set up a single day. We'll talk about it next week between the end of class and the final exam, where I'll come on campus and I'll just be there for the whole day. And you can come to my office hours at that time if you would like. If you have any questions. Tentatively, I'm thinking of making that April 7th. I teach another course from 1 p.m. To 4 p.m., but I can come in the morning and be there basically until 1 p.m. So I'll tentatively set up for that, but we'll talk about that a bit more in class. Okay, so just again, how to do well. I want to review this to make sure we're all on the same page. Everyone's getting the same information, right? In terms of answering questions, try to answer the questions using the IRAC method for those questions that are worth more points, right? If there's a question that's like a follow-up question, like similar to the midterm, where it says, would your answer change if this, or introduces a very small thing and asks a very pointed question, those are usually worth 2 to 3 marks, right? Those you just can answer and explain your answer. But for the rest, what we're looking for is a fulsome answer, right? And the way to answer these is to follow some form of an IRAC method, right? And again, we don't ask you to do this because we care about formatting. We don't ask you to do this because we're sticklers for certain ways of putting your answers together. It's really a framework for you to do well, right? And if you follow it, what's going to happen is it's going to force you to write your answer in a way where you're communicating all of the important information, you're not missing anything, and you're going through the logical reasoning process and explaining your answer really well, right? That is possible to do without this, right? Definitely. But this is a nice tool to use because it forces you to hit all the relevant points, right? So again, just to review, IRAC is you first start with the issue. You should state the issue in a way that can be answered by your conclusion, right? So for example, on the midterm, we were talking about negligence, right? The issue is the defendant liable in negligence? Your conclusion is yes or no, they are, or they are not, or they're likely to be, or they're likely not to be, right? And then the rule and the answer is going to cover, the rule is the legal principle, right? That applies to answer the issue, right? So again, going back to my example of negligence, which I know is midterm content, not final content, but just to explain, right? The rule is the legal rule, in that case, duty of care, breach of the standard of care, causation, damages, right? You're not talking about the case in the rule section, you're talking about the legal principle that applies to answer the issue, right? And then in the answer, you go systematically through the rule and you apply it to the facts of the case, right? And it's here where students kind of differentiate between a B answer and an A answer, right? In this analysis section, what we're looking for is your ability to analyze the issue fully, right? And that involves not only having a superficial analysis where you just state your conclusion, it involves going through the steps, identifying where the tension points are going to be between the parties' positions, exploring those tensions, right, which I often call in class counter arguments, right, and then resolving them, right? And that's difficult to do. That's what differentiates the B and the A answer, right? What you have to be able to do to perform well is to truly understand the content in the course such that you're able to pick up on where those tension points are going to be. You're able to see the issue from both perspectives, the plaintiff's perspective, the defendant's perspective, and you're able to talk about those issues where the tension points are going to be in a fulsome way and explain and resolve them, right? So that's kind of what differentiates the B answer from the A answer. I want to pause here to talk about a question I often get about the final exam, and that has to do with the rule, right? For the midterm, it seemed like we always had these multi-part tests, right? Like negligence, a 4-part test, battery had a 2 or 3-part test, depending on how you formulate it, right? All these steps, right? And in the second half of the course, there's some of that, but not as much, right? And so students often get confused and they're like, well, what's the rule, right? So that's often a question I get. So I'll pause here to talk about that for a second, right? And so the rule is whatever the legal principle, we call it doctrine, whatever it is, right, to resolve the problem, right? So I'll just give you an example from the second half of the course. We learned about how you can fire employees, right? There's no multi-part test, but we all know the legal doctrine having gone through it together, right? So how can you fire employees, right? The rule is you can fire an employee for a cause, right? In which case you don't have to give them notice, or you can fire them without cause, in which case you have to give them reasonable notice, right? And then in determining reasonable notice, these are the factors that we look at, the Bardell factors, right? And that's the legal doctrine, right? So the fact that it's not in this nice, neat, multi-part test is irrelevant, right? And so don't let that trip you up, right? The rule is just always what is the legal principle, the legal doctrine that we learned in class, right? Explain it. Then the analysis, application section, that's where you apply it to the facts of the case. Okay, so that's going to bring us to what we've covered in the second half of the course. This is a comprehensive look at what we've covered. There's some things here we haven't talked about yet because we still have class next week. And so we'll talk about those next week. I won't go through them now. Okay? And so we started the second half of the course by finishing up contract law, right? And where we started was talking about this idea of privity of contract. So you need to understand that only the parties to the contract are bound by the agreement and can enforce the obligations pursuant to that agreement, right? That's what we call privity. So if someone is privy to an agreement or has privity of contract, what that means is that they are bound by the terms of the agreement and they have the right to sue someone if the other party breaches the agreement, right? We then moved on to this concept of assignment, which is when one party can assign their right to another party. And we talked about 2 types: statutory assignment, where it meets the obligations of the statute, the notice is in writing, the assignment contract itself is in writing, and it's absolute, meaning there's no conditions attached to it, right? And then we learned about the equitable assignment principle if those elements aren't met, right? And the important thing to remember here is no matter how it's assigned, the effect is the same. When someone is assigned contractual rights, then the other party must perform their obligations towards that new party who we call the assignee, right? We then went into discharge of contracts. This answers the question of when is a contract over. First 2 were really easy. Contract's over when the parties fully perform their obligations, right? Or the contract's over when the parties both agree that it's over, right? Which can be done in advance in the contract itself, or on an ad hoc basis after the fact, right? Then the 2 more interesting ones was discharge by frustration. This is where something outside the party's control happens after the contract is formed that makes the contract either impossible or fundamentally different from what the parties had agreed on, right? And this is a high bar, right? And it's very difficult to meet. Mere price increases, for example, are not going to be enough, right? We then talked about discharge by operation of law, right? There were 2 situations we talked about. The first was the Limitations Act, right? The idea here is you have 2 years to sue someone. So if you don't sue for breach of contract in 2 years, you lose that right? And then the second one that we talked about is discharge by bankruptcy, right? And the idea here is when you declare bankruptcy, the purpose at the end of the bankruptcy, when you're discharged from bankruptcy, is to end all of your debt obligations, your debt contracts, right? And so those get discharged in that process. We then talked about exemption clauses. You'll notice, I just noticed this now, but on the left, it's highlighted. On the right, it's not. That's just a mistake. They should both be highlighted. There's no difference between those two things. They're the same thing. And so the exemption clause are circumstances in which there's a clause inside a contract that purports to exempt someone or limit someone's liability, right? And here we're always going to apply the test from Turk-on contractors, which first asks whether or not the clause itself applies to the facts of the case, right? And then we get into whether or not the clause is unconscionable or should otherwise not be enforced due to public policy, right? We then learned about the difference between a condition and a warranty. Condition are major terms in a contract, warranties are minor terms, and therefore a major breach of contract gives the innocent party the right to discharge the contract, right? They have a right to get out of the agreement and stop all future obligations under that contract. And then sue for damages, of course. But if it's a minor breach of contract, the innocent party does not have this right, right? The innocent party is still bound by the obligations of the contract, and if they fail to perform, they can be sued themselves. Breaches can occur in multiple ways. A party could just perform badly. They don't meet their obligations. They don't perform at all, right? Or they call up the other party, email the other party, tell the other party in any way that they don't intend to perform, right? That's an express repudiation. We then talked about the doctrine of substantial performance, the main thing here being, right, that if a party substantially performs their obligations under a contract and the contract requires a party to perform all their obligations before they get paid, then a substantial performance is going to be enough to get paid, and then you can sue for damages for not performing fully. Okay. We then talked about remedies for breach of contract. Remember, the key difference here is, unlike tort, where we're trying to place the party back in the position they were before the tort occurred, right? For breach of contract, we're forward-looking. We're trying to ask, what position did the innocent party expect to be in had the contract been fully performed? What position are they in now because of the breach? And we're going to compensate them for that difference, right? We call this expectation damages. A party might also be entitled to consequential losses. So things that are a consequence of the breach, right, but aren't necessarily part of the contract. So for example, we talked about in class a supplier not showing up and delivering their supplies, right? So the fact that they didn't get the supplies, you're gonna have to put them in the position they would have been had they gotten the supplies, right? So compensating them for any changes in prices to go out in the market and buy a replacement, right? However, they might not be able to open up for business that day and they lose profits. That's consequential losses, right? And so long as those are reasonably foreseeable, they are also compensable. And then we also talked about general damages, which is loss of goodwill as well, right? We then briefly talked about equitable remedies. These are things like injunctions, which you can get to stop a party from doing something, right? These are things like specific performance, where you can force a party to perform their obligations under a contract under threat of contempt of court, right? These are reserved for situations in which damages are not going to be sufficient, which means they are reserved for situations where the money cannot be used to go into the market and find a replacement good. That means that the goods are non-fungible, meaning that they are so unique that money is not going to be enough, right? We then talked about this idea of quantum merit, which I said was not that important for the course, and so I wouldn't worry about that too much, right? We talked about the obligation to mitigate damages. That is, the innocent party has an obligation to, quote unquote, stop the bleeding from a breach of contract. So they have to go into the market and try to find replacement goods, try to find replacement buyers, right, depending on which side of the transaction they're on, right? And they can't just sit there and say that there's a breach of contract and now they've suffered an insurmountable amount of damages, right? They have to go try and mitigate them. We then talked about some unique issues in calculating remedies, right? So the cost of performance versus economic loss issue. This deals with what happens when there's two different ways to look at a case, meaning you can phrase the expectation as a lost cost of performing the contract versus the economic loss resulting, right, from the breach of contract. And those two things can often compete. And as we learned, what the court does is they step into the shoes of the innocent party and determine, well, if we gave them the higher amount, what would they actually do with that money? Would a reasonable person actually, for example, remediate the land in the example I gave in class from PB House and Garland Cole, right? Or would they pocket the money, right? And if the answer is they would pocket the money, then you have to go for the lesser amount, right? We then briefly talked about how you can enforce a judgment. Remember, when you win a lawsuit, what you get is a piece of paper called a judgment, and that's it, right? And that piece of paper, right, allows you to enforce the obligations under the contract, which usually means that you are going to go try and execute, right? So either the party actually pays you pursuant to the judgment, right? Or you have to go try and execute the obligations under that contract, which traditionally means that you're going to, for example, get a garnishment order to garnish their wages, get a garnishment order to garnish their bank account. You're going to get a writ of possession and sale to take their property and sell it on auction and collect your money. So now we're going to get into agency and franchising. So remember, agency law deals with a situation in which one party, the principal, is trying to kind of hire another party who we call the agent to enter into contracts on their behalf, right? If you ever forgetting what this is, just think of a real estate agent, right? You hire an agent, the real estate agent, to buy or sell your house on your behalf. That's just an agency relationship, right? And the key things that can happen here are questions about whether or not that agent actually has authority from the principal to act on the principal's behalf, right? And so long they have actual authority, or what we call apparent or ostensible authority, remember those mean the same thing. They're synonyms of each other, right? So long as you have either of those two things, then there's always going to be a contract between the principal and the third party, right? So long as the agent has actual or ostensible authority to act on behalf of the seller's behalf, then if the agent purports to sell the seller's house to a buyer, then there will be a contract between the seller and the buyer, right? So long as that all goes according to plan, right? And actual authority is easy. That's when the agent actually has authority to act on behalf of the principal's behalf. Ostensible apparent authority asks a different question. This is based on the actions of the principal, right? Was it reasonable for the third party to believe that the agent had authority, even if they didn't, right? And this often most commonly arises in situations when the agent exceeds their authority. There's a limit to their authority, a dollar amount or a type of thing they can do, right? They exceed that, they go above and beyond that. Now we need to ask, was it reasonable for the third party to believe the agent had authority, right? Based on the actions of the principal, not the agent, right? We then learned about the idea of the duties between the agent and the principal. The agent owes a duty of good faith, right? That's a fiduciary duty, right? And they owe a duty of care to not be negligent, right? To the principal. These are both owed to the principals. And then the other way around, the principal only owes a duty to the agent to comply with the contract, which means they have to pay them. And the default rule is they need to reimburse them for any expenses, right? The rights and liabilities of the principal and the agent of the third parties, as I discussed, has to do with whether or not the agent had authority or did not have authority, right? And that depends on the analysis we just went through. We then learned about undisclosed principals, right? And undisclosed principals are situations in which the principal's name and identity is not disclosed, but the agent says that they're acting on behalf of an undisclosed principal, right? In these situations, there's only two options. The agent had authority or the agent didn't, right? And the results are the same. In terms of torts, the agent and the principal are both jointly and severally liable for all torts committed by the agent in the course of their duties, right? We then learned about this concept of breach of warranty of authority, and this concept is almost like a misrepresentation claim. So if the agent misrepresents their authority, right? They make a warranty that they have authority to act on behalf of the principal's behalf, but they don't, right? Then the third party can sue the agent for breach of warranty of authority. They would all also succeed in a claim of misrepresentation, as we discussed, but this is much easier to prove. You just need to prove that they gave a warranty that they had authority and that they didn't. That's it. Much simpler than the test for misrepresentation. We then learned about how agency relationships come to an end, and I won't repeat them here because we already talked about discharge of contracts, and the answer is the same, right? And so agency agreements discharge just like any other contracts. Discharge, that means it's done, the project's done, right? The parties have agreed it's over, pursuant to the terms of it. The individual goes bankrupt, there's frustration, right? All the same. We then talked about franchise law. And remember, franchise law is this interesting area of law. It's what we would say sui generis, meaning it kind of stands on its own. It has some overlap with some common law, but it's interesting because it's kind of different. And the main issue that we talked about in franchise law is the obligation to disclose, right? And so prior to a franchisee entering into a franchise agreement, there is an obligation on the franchisor to disclose very specific information that's found in the regulations of the Arthur Wishart Act. Generally speaking, they must disclose all material information to the franchisee. And if they don't, this gives the franchisee the right to rescind the contract. Right? We also talked about the right of franchisees to associate. This is almost like unions for franchisees. They're often called franchise associations. And the franchisor cannot interfere with that type of activity in the same way that an employer cannot interfere with employees trying to form a union. We then went into employment law, right? And we learned about, remember, two big things here, and that's all I'm going to focus on here, although there is more on these slides, right? And the two big things we talked about is the difference between an employee and an independent contractor. And recall there was a table that we walked through. I'll talk about some of the important things on that table. But things such as independent contractors tend to bring their own tools, whereas employees tend to be given the tools of the trade by their employer, right? Independent contractors have complete control over their schedules, right? Whereas employees often have to work at certain times and are told by their management what to work on. Independent contractors often have multiple dozens, right? Hundreds of clients. They're a business, right? Whereas employees often only work for one company at a time. There's exclusivity often, right? Independent contractors, the key idea is that they are a business, meaning that they take on business risk, which is a risk of profit or loss, right? Employees don't take on that risk. They show up for 40 hours a week, they get paid their salary. They show up, they're an hourly worker, they get paid per the hour. If they're a worker that earns a commission, they get paid if they meet their commission, right? Independent contractors don't have that benefit. They have to chase their own bills. They're their own business, right? Chase their own invoices, right? And that's kind of the key difference between these two things. The mere fact that you call someone an independent contractor or an employee is largely irrelevant. The courts largely ignore that. They're going to look at the facts of the case instead. That was the first big topic we talked about. Then the second big topic we talked about, which I've already talked about a little earlier, is how you can terminate employees. And recall that there are two ways you can terminate: with cause, meaning that the employee, there was employee misconduct, right? Which often means they were insubordinate, didn't follow rules. They breached the duty of good faith, right? They're competing with the company or stealing trade secrets from the company. Or they breached a company policy, right? Things like that are going to give the right of the employer to dismiss with cause. But to do so, you have to build a proper record. So you have to give warnings, opportunities to improve, training, etc. Unless there's something really big that happened, like in employees, you have them on camera stealing $1,000 from the cash register, right? Something like that, or they're harassing customers. Absent extreme things like that, you have to build a record, give opportunities to improve, provide training, and then only then can you dismiss. Right? That's with cause. If you dismiss with cause, you don't have to give any notice. They could be dismissed the same day, and you don't owe them anything other than the pay for the work that they've already done. Right? The other alternative is to dismiss without cause. Okay? And to dismiss without cause means that you have to give reasonable notice so that they can find a new job. Right? And this often means you're not going to actually give them notice. Right? You're going to give them payment in lieu of notice. So they're going to go home today. You're going to pay them out for the reasonable notice period, but they don't have to show up to work, right? And we determine the reasonable notice period first by looking at the contract, but as we discussed in class, often these contracts are illegal or unenforceable, not always, but very often. And therefore, we have to look at the common law, which is called the Bardell factors. And we look at things such as how long has that employee been working there? We look at things such as what is the normal trade usage within that industry? So what's normal within that industry? Um, we look at things such as how senior is that employee within the company? The more senior, the more time, right? And then using that, we come up with a reasonable period. The rule of thumb is roughly 3 weeks per year of service. But again, that's a rule of thumb. And so those were the two big things that we learned. And if those are not followed properly, that is the two ways in which you can dismiss an employee, then an employee is going to sue their employer for the cause of action called wrongful dismissal, I should say. And in their defense, the employer is going to say, well, we had reason, we had cause, or we gave reasonable notice, right? We also learned about this concept of constructive dismissal. This is when the employer tries to coerce the employee to quit such that they don't have to dismiss them and pay them for being dismissed without cause, right? And this can happen in several ways. You can move an employee to a new office that's further away from their place, their home, right? You can change their job description, reduce their pay, make a toxic work environment, et cetera, et cetera. Lastly, we kind of learned this concept of what are the damages if you succeed in this claim of wrongful dismissal or constructive dismissal. It's always going to be the reasonable notice period subject to a duty to mitigate, which means to find a job. And you're very rarely going to get punitive damages. This requires the dismissal to be high-handed, right? And this requires the dismissal to have a separate actionable wrong, which usually means something like defamation, something like breaching employment standards. There has to be something else that happened. And then only then can you get pain and suffering damages or punitive damages. That then brought us to secure transactions. And remember, secure transaction is dealing with how do we securitize debt, which means how can we reduce the risk of debt by using an asset as collateral for the debt or the loan, right? So this is collateralized debt obligations. We're going to use an asset to collateralize the loan. So if the loan is not paid, the creditor can take the asset, sell it, right, and then get their money back, right? And we learned about 3 types of secured transactions. The first was what we call a chattel mortgage. The second was a conditional sales contract, and the third was a floating charge. Remember, chattel mortgage conditional sales contracts are used when you have a specific asset or a group of specific assets that can be identified, right? Usually by description, serial number, VIN number, something like that, right? And the only difference between these two is the chattel mortgage is owned by the debtor, the asset is owned by the debtor, right? Whereas a conditional sales contract, the asset is owned by the creditor, right? This is like the difference between a lease, conditional sales contract, it's owned by the dealer, right? And a chattel mortgage, financing a car, the car is owned by the debtor, right? Not the creditor. And which would be the driver in this case, right? That's the only difference. Floating charges are used when you don't have a specific asset, but you have a large group of assets that tends to change hands over time, something like inventory, something like accounts receivable, right? And the idea is you have this blanket that floats over those assets until there's a non-payment, then it attaches to all of those assets, right? And then now the creditor can take them and sell them, right? We then learned about how you create these things. There's a 3-step process. You first create the security agreement, which just means you're signing this contract called the security agreement. The second is that security agreement then attaches to the property once the proper party owns it, right? Or in the case of a floating charge, once it drops and attaches to that property. And then you have to perfect it. And there's 2 ways to perfect this. One, you file it under the PPSA database, right? 2, the creditor possesses the property, not owns it, but possesses the property. Okay? And we learned about the 2 benefits you get from this. First, if the debtor doesn't pay their debt, the creditor can immediately take the asset that's being used as security for that debt and sell it, versus going to court, waiting the 7 years to get a court judgment and trying to enforce it using a writ of possession and sale. You could do that immediately without the intervention of the court, right? Second is if the debtor declares bankruptcy, you get priority in bankruptcy over that asset, right? So if you have like a car as the asset, you're owed $10,000. The debtor declares bankruptcy, then the creditor in bankruptcy is going to go sell that car. The proceeds of that sale first are going to go to you as the secured party. And as we learned, parties can have security over the same asset. And so we determine the priority by whoever perfected first, right? Which usually means whoever filed under the PPSA first. That then brought us to business organizations. We learned about the 3 different ways in which you can run a business in Canada. We have the sole proprietorship. The benefit of that is it's quick. You put up a shingle, you start doing business, right? Very easy, but high risk. The business is you. There's no separate legal entity. Right? We then talked about partnerships. The key here is that a partnership automatically arises whether or not you want one when there are 2 or more people doing business with a view to profit in concert together, right? If you meet that test, you are in a partnership. We learned about 3 types of partnerships. The general partnership is the basic one, right? We talked about all the basic rules, and just remember, right, if you're trying to figure out those rules, a partnership is just a web of agency principal relationships. That's it, right? So they owe each other fiduciary duties. The partnership is over, right? Once one of the parties gives notice, just like an agent can give notice, right? All of those things you can derive, right? A partnership doesn't exist at law. It's not a thing, right? A partnership just describes the partners. That's it, right? Meaning that all the partners are jointly and severally liable for all debts, obligations, liabilities of the partnership. If one partner commits a tort in the course of business, all of the partners are liable, in the same way that if an agent commits a tort, the agents and the principals are jointly and severally liable, right? We then talked about 2 different types, additional types, I should say, of partnerships. The limited liability partnership, which exists primarily because professionals cannot incorporate for a very long time. And therefore, we had to create a new entity called an LLP, where mostly law firms, accounting firms that couldn't incorporate ran business this way. What this means is that one partner is not going to be liable for the negligence of another partner, right? Unless they were involved, of course, right? And so the partners to this partnership, an LLP, are only liable for their own torts, their own negligence, right? And so this helps alleviate the concern that you're going to be liable for another partner, right? We then learned about LPs, which solves the problem that investors, passive investors, don't want to invest in partnerships because they don't want to become liable, right, as a partner. So an LP splits up the partnership into 2 types. We have general partners. Those are the managers of the business. The managers of the business, the general partners, are 100% personally liable for all the debts and obligations of the partnership, just as a normal partner would be. But then we introduce a different structure called an LP, which is a limited partner. Those partners cannot take part in the management of the business, and their liability is limited to the amount they invest, almost like a shareholder, right? If these LPs do take part in the management, they will be deemed general partners, and they open themselves up to unlimited liability. Lastly, we talked about corporations, right? And the big thing in corporations is that it is a separate legal entity, right? So as a separate legal entity, this means that corporations can commit their own torts, commit their own crimes. They have their own constitutional rights, right? It's a very interesting way of doing business, and one of the most modern ways of doing business. Okay. We then talked about internal corporate governance, and this is the last topic I will talk about today, because we just talked about this last week, and so there's no need to review it in detail. And in corporate governance, what we're concerned about are the internal operations of the business, right? Last class, we talked about the external, and again, I won't talk about that because we just did it. And for the internal operations of the business, right, we have different constituent parties. We have the directors, we have the officers, we have the shareholders, right? And recall, the directors, the first directors are listed in the Articles of Incorporation. They then have the first annual general meeting and they vote in the directors. The directors usually have an office term of 3 years. Then the shareholders vote in the directors. That's their obligation to do. The directors then hire the executives, the CEO, COO, CTOs, etc., right? And those executives manage the day-to-day business and they report to the directors, right? Remember, directors and officers owe the corporation, right, a fiduciary duty and a duty of care. We then talked about the different types of resolutions. So shareholders have to vote on some things, things like electing the auditor, approving the financial statements, stuff like that. That's just an ordinary resolution, often happens at the annual general meeting. We then have special resolutions. These are for important things such as amending the articles of the incorporation to, for example, change the share structure or change the nature of the business, or if the business is going to acquire another business or be amalgamated or merge with a different business, right? These require a special resolution, which means you need 66% of the votes plus one to succeed. Ordinary resolutions just 50%, right? And the big topic that we talked about here in the shareholder rights area was the protection of minority shareholders, right? And recall there's kind of two problems. The first problem is in a private, non-public business, there are share transfer restrictions on the shares, meaning that the shareholders can't sell the shares to the public, right? This is why they're private. The only way they can sell the shares to the public is to find a suitable buyer. There's no market for it, so they have to go find one. Yeah, and then get the transaction approved by the board to make sure that you're not going against securities laws, right? This can be a long, arduous process. It's not very easy to liquidate your investment in a private company. And so we call this the locked-in problem. And so we need certain ways for these minority shareholders to dissent, to get out of the business if they don't agree with the way it's going, right? Remember, in a public company, you have the self-help remedy. You press sell in your app and you get out of the business. Private, it's much more difficult. So we have three main ways to get out of this. The first is what we call the dissenting right, which is often, as you'll see here, just referred to as the appraisal remedy, right? These are coupled together. The idea is if you're going to have a special resolution, one of those major decisions, the minority shareholder who disagrees with it can dissent. They write a letter to the board saying, I dissent, right? If they do that, the corporation must buy back their shares at fair market value. If the parties cannot agree on what fair market value is, then you go to court for what's called the appraisal remedy, and the court tells you what fair market value is. Okay? So that's the first. The second is what we call the winding up remedy. This is the nuclear option as discussed in class. Very rare for this to happen, but if there's no possibility of this corporation continuing, then you're going to wind up the corporation, right? Shut it down, sell the assets. That's what that means. We then talked about the oppression remedy. The oppression remedy is the most common remedy. This happens when the minority shareholders have formed some reasonable expectations, although as discussed in class, it could also be creditors, it could also be other stakeholders. But for the context here, we're going to focus on shareholders. They form some reasonable expectations, and those reasonable expectations are breached by the company, the board, the executives, in a way that is oppressive or unfairly prejudicial, right? So they're ignoring their interests in something. Has to be something more than just, I disagree with what they're doing. They have to be doing something that is oppressive towards this individual or group of shareholders, right? And then lastly, we learned about a different problem. So that's how we solved that first problem. The different problem is, as we discussed, the directors and officers owe their fiduciary duties and duty of care to the corporation. So now what happens if the corporation is not suing those directors and officers, right? Usually because they're the ones doing the bad thing, and they are the ones who decide and approve of the corporation to sue themselves, right? And so in that case, we have something called the derivative action. The derivative action is you're going to court to get permission from the court, right? This is a permission, and you're getting permission to ask the court whether or not you as a shareholder can step in the shoes of the corporation and bring such an action, right? There's a three-part test for this. You have to be acting in good faith, which means that you're not bringing this for ulterior bad faith purposes. The action has to be in the best interest of the corporation, right? And lastly, the directors themselves have to not be authorizing the corporation to bring the action. So like I said, I'm going to pause here for the kind of the rapid fire review, because we just talked about these last things last week, and we're going to talk about these next week. So I'll leave the review there. We are going to finish all of our content on Tuesday. Thursday, we will take up the practice final, and you can ask any questions that you have at that time. So good luck with studying. I'll see you guys all on Tuesday.